Hello, everybody. My name is Leonid Morozhkovsky. I'm an attorney licensed in the state of Texas and state of Illinois. And I have with me Robert Robb. Robert?
Howdy. Pleasure to be with you, Leo.
Absolutely. It's always nice to see you. Robert, would you please tell us a little bit about yourself? Who are you and what do you do?
Absolutely. I am a multifaceted person. I own a dog. That gives me great credentials, but I live in Frisco, Texas. I've got 15 years as a university level professor and 2 decades as an ordained minister, similar to my friend Leo, who is also ordained. And I've also got 15 years in the financial services industry, working for two multinational companies. I have experience with consumer and business banking, mortgages, IRAs, helping people plan for retirement, various other things. I have set up trust accounts, estate accounts, POAs, TODs. Right now I'm helping with PPP loans, and that's a lot of acronyms. But today I am not representing the bank, and I'm not soliciting for accounts or financial services. What we're doing today is just really educational. So I'm coming here as an educator, a minister, and a friend of Leo to maybe plant some seeds for our listening and watching audience that they would start thinking about making sure their estate is bulletproof.
Awesome. Thank you very much. Well, everybody, again, as I said, my name is Leo. I'm an attorney. I mainly practice estate planning, business planning, and real estate law. In essence, I deal with other people's money. This is what I do. My job is to manage it for others, make sure that they have a plan. So today we're going to talk about estate planning. I know it's not the best time to do it. I know everybody's scared right now because of what's happening, but also it is the perfect time to talk about it. It's a perfect time to see if you have a plan. Do you need a plan? What is estate planning? Is it for everybody? Is it not for everybody? And the basic answer is, well, nobody needs it. It's something that you want to have. Whether you want to have it depends on your situation. But let's hear. That's why we're here to talk about it. Who needs an estate plan? Nobody. Literally, nobody needs an estate plan. This is not food. This is not water. But who wants an estate plan? Pretty much everybody. Why? In essence, it's going to help your loved ones take care of your business once you're gone or incapacitated. So one of the things we need to talk today about is a simple list of documents, which I would prefer everybody to have. And I'm going to go back to Rob because we're going to talk today about powers of attorney. Rob, what do you
Simple.
know about?
Why are we doing it simple? I thought we were supposed to make it complicated. You've got to
No, no, not today. Today's a basic. We're going to do easy.
let
So
me let me let me share real quick a biblical anecdote that I think will kind of fit this little setting here. In Numbers 27, there were these five daughters of this man named Zelophehad who died, and back in those days, the inheritance laws passed from the father to the sons, and this guy had no sons, so his daughters had to go to Moses and appeal to him, and Moses appealed to God, and God made a ruling about that daughters could be included as inheritors of a father's estate. And I was thinking about this. Hey, good luck going to God, or good luck going to a judge and saying, God told me that I was going to be the inheritor of an estate with no plan. And so now we do things a little bit differently. And I think it's important to have a really bulletproof plan in place.
Oh, absolutely. And let's start with the basics of a plan. So, the powers of attorney. You, as a banker, tell me about it. What do you know about powers of attorney? What have you seen in your
Yeah.
professional life?
Well, I have seen people come to the bank after parents and spouses and partners are hospitalized. Maybe they've had an accident of some sort, an aneurysm. They can't make decisions. And they come wanting help because they've got to figure things out. They've got to get bank documents to qualify for Medicare, Medicaid. The nursing home wants financial documents to make sure they can pay for it. And they don't come with any power of attorney. And guess what I can't do? I can't help them.
Absolutely. The federal law prohibits you from releasing any kind of financial information. Even if the child comes in and says, look, my father is in the hospital. I need it. I need to pay for it. I need to pay for this. I need to pay for that. your hands are tied. The federal
Now,
law and state law.
and what I do, Leo, is I do my best to think with them. I don't just say I can't help you, go away. I
Sure.
mean, I sit there with them during some of these heartbreaking moments, and we start thinking about how can we get around this legally, ethically? Who can we call that can help? And inevitably, you know what the words I tell them are? You're going to have to go to an attorney, and you're going to have to go to the probate court and get a ruling that allows you to make financial decisions and power of attorney decisions and things like that, because I can't do it for you. It's too late.
Well, absolutely. On a simple note, also, it's nice to know that powers of attorney only work up until the death of individual. So the power of attorney is a living document.
That's
So
right.
as long as the individual is alive but unable to make decisions, financial power of attorney is a beautiful, beautiful instrument. Now, a good lawyer obviously will talk to a client, but in Texas, you can have powers of attorney be available upon the disability or immediately.
Right. Or simultaneously, right?
Absolutely, it will talk about what are the availabilities. So when somebody would come to me and we talk about their financial situation, their family situation, we could actually make a decision whether to make the power of attorney uh, be active today as of signing, or only upon disability once a doctor makes a decision that the individual cannot make decisions for themselves. So a power of attorney is a beautiful, beautiful document to have. It's for anybody that has children, that has a family, that is probably over the age of 40. This is not a bad document to think about.
I think it's necessary. I
Well,
mean,
absolutely it is, but in essence, it's one of those things where let's go back to the first premise. Who needs it? Nobody needs it, but who wants it? Everybody wants it,
yeah.
right?
It's
So,
contingency too. We have to plan for the things that we don't want to happen, but that could happen.
well, absolutely. Look what's happening right now. Who would have thought? And
Yeah. Somebody's quarantined. They need some help. They can't get out. Kids
absolutely.
can't go to the bank and pull money out of their account for them, or because they don't have a power of attorney in place.
Absolutely. So let's say you're an elderly individual, you're literally stuck at the house, you can't leave. Yes, you can call your banker and leave the voicemail, but what if the banker is unavailable? What if somebody actually has to go to a bank?
Yeah.
They send in somebody, let's say a niece, to go pick up some documents from the bank or do some business with the bank. Guess what? Power of attorney. If you don't have one, the niece will be turned away. Nobody's going to talk to her. So important, important, important. If it's not on your to-do list, please make it into a to-do list. Speaking of powers of attorney, the next power of attorney is a medical power of attorney. That power of attorney somebody should have, period. This is a document that you got to have. If you have any kind of medical condition, if you're over the age of 40, if you're going overseas and you're not sure what to do. Now, speaking of overseas, these documents are going to work pretty much everywhere in the United States. As overseas, who knows who can control that. But it's one of the documents you got to have. And basically, it's a laundry list for an individual who will take care of your medical needs, meaning you cannot be vocal. You're about to go into surgery and somebody needs to make a decision. If you have your wife or a husband, a spouse, he or she can automatically make those decisions. If he or she is not allowed to make those decisions because incapacitated, she's no longer here longer with us, or simply far away, who is next going to make those decisions? This document clarifies it.
Now, can I interject something in there?
Absolutely.
You know, so does that mean that that individual just makes some random decision, or is that individual supposed to carry out your wishes in that document?
Actually, the power of attorney allows the individual to make medical decisions. There is another
Period.
document we can actually add to it, which will limit what kind of decisions can be made. But this is a very powerful document. Power of attorney for medical is sweeping.
Okay.
So this is the document that will allow somebody to consent for an operation, to let's say consent for blood transfusion if such is needed. And as you know, for certain groups of Christians, blood transfusions are very important.
Sure.
Well, they're important not to do. So
Sure.
it's a sweeping document, right? But again, going back to the planning, if we're in the planning stage, if we're talking about it, if this is a family decision, this is
Sure.
what you talk about during your, well, once a year family meeting on family affairs, or once every 6 months family meeting, right? Where family sits down and we talk about what documents we have, what's happening in the family. And this is a document you need to talk about.
Now, I know you've seen this, Leo, and I've seen it in my experience as a man and a person that's involved in people's lives in ministry and banking. Is one person wants to pull the plug, a do not resuscitate order, because they know that was dad's wishes. The other sibling doesn't want that to happen, and they can't agree, and somebody goes to the court. What happens in those situations? Where's the final ruling and the arbiter that settles it?
There's another document that can be done. It's called Directive to Physicians. Basically, it's the last will. It's what's called a living will. Okay, this is the document where individual specifically outlines his wishes, so that we're not gonna have all of these issues. Like, in the past 10 years, we've seen all these news outlets reporting about people being pulled off support, on support, family feuds, this and that.
Sure.
We talk about it. We talk about it in church. I'm sure you've delivered a sermon about it. And it's polarizing.
Yeah, it's a mess.
All of it could have been avoided if all those individuals had directive to physicians. Properly done, of course. And that's the document that limits the power of attorney, of course. And it also limits the ability of doctors to continue life support if you choose not to, or vice versa.
Sure. Now, quick question. Do you think sometimes, and I hate to say this, but I'm just going to bring it up, money comes into play with hospitals and doctors in some of these decisions? For instance, if doctors prolong the inevitable, hospitals prolong the inevitable, like, for instance, dad should have had the plug pulled 2 weeks ago, but they've kept him on life support 2 more weeks. How does that affect the estate financially? Is that a profiteering sometimes, I hate to say it, moved by the hospital, by the physicians? There's money in medicine, right?
Right. And the answer is, we don't know.
We don't know.
We don't. But we also know that we have a logic in our hands, right? We also understand that we have a document that basically says, do not resuscitate. Let me be. We have family members that no individual did not want to suffer.
Sure.
And then we have a doctor who basically pushes for another week. And
if they don't have that document and it goes to the courts and there's a 2-week span, does that affect the financial health of the estate?
Absolutely.
Do they have to pay the medical bills?
Absolutely it does. But the whole idea is this, going back to planning. Do not allow this to happen.
Yes. That's why I bring these questions up and these
Absolutely.
anecdotes.
Do not allow this to happen. See, I don't do litigation. I don't do any of those things. My job is to never set a foot inside of a courthouse. My job is to plan. My job is to educate. My job is to make sure that none of my clients will ever see inside of a courtroom, period. That's what my job is. And if somebody's going to court, we already failed.
Yeah.
The question is how badly, right? So that's the planning portion of estate planning. And estate planning is way more. It's a way of doing business, right? Estate planning encompasses financial planning, right? Something that you know everything about, right? Financial planning and estate planning are brother and sister. They're always set together. You cannot do estate planning without financial planning. And doing financial planning without estate planning is simply not a good idea.
If you have no assets, you don't need an estate plan.
Right?
Let's be honest, it's not for you, it's for those coming behind, obviously apart from some of the other documents, POA and things like that, but your estate, you don't get to spend any of it.
Absolutely. And when people come to my office and we do estate planning, I tell them, look, the basic idea of estate planning, if it's properly done, is for you to bounce your last check.
Exactly. Yeah.
That's the whole idea, because we know you cannot take it with you.
Sure.
So the question is, again, two philosophies. Either you spend it all and your last check bounces, or You accumulate it all and you pass it on, right?
Sure.
And all of that is still estate planning and requires planning. Speaking of passing on, as you might know, and if you don't, I'm telling you that if not properly educated uh, family or devisees, right, receive a lot of money, it is
Sure.
usually said by the third generation, the family will lose most of its wealth.
Yeah.
Estate planning, financial planning also comes with education because it'll take more effort to keep on to the money than to actually make it in the first place.
Sure.
All of this is a combination, right? It always goes hand in hand.
Give an example. I've had parents come in with multiple children, and we've set up trust accounts at the bank and things of that nature. And one of the children might have had in the past a drug problem, and a lot of money is a trigger. The other maybe just gambles. And I've had these situations, and they've put limiting things within the trust as to how much money they could get paid from that per year, so it doesn't become a problem for them, so it doesn't trigger them. And so, there are various instances where, you can kind of control things about your money after you're gone, if necessary.
Absolutely. And again, most of it is done for the benefit of those that you will leave behind.
Sure.
Speaking of those that we leave behind, I had a number of my clients. At first, I was a bit shocked, but now it's to me is real. They leave money to their pets.
Sure. Absolutely.
It might be strange, it might be not, but it's their money and it's their wishes. So again, planning. They actually thought about planning to make sure that their pets are taken care of.
Sure. I had a friend yesterday or 2 days ago post on Facebook that his little dog Shorty, who we have house sat for, passed away.
Uh,
Beautiful little box. They buried him in the backyard, and they tagged us because we had house sat. Shorty was 15 years old. And so you have someone buying a pet, and they think it has another 10 years of life expectancy. Who's going to clip its nails and groom it? It's just the little details of life, and I think it's important. And you've also seen, on the other hand, people haven't thought anything about their children or their grandchildren. They've let their estate go to the probate courts and get dissolved up by lawyers and judges and squabbling in the family. And so the point is, if some people have the forethought to even care for their pets and to plan for that, dear God, we need to plan for our spouses and our children and our grandchildren and make sure those details are carried out according to our wishes and with common sense.
so a little bit of good news.
Good
Texas,
news.
yes, good news. Texas has one of the easier probate systems in the states. Okay, we actually have it somewhat efficient compared to other states, and not as expensive as other states. So if we're
Yeah.
talking about the scale of horrible things that could possibly happen, then going to probate in Texas is not as bad as going to probate in New York or Illinois.
Beautiful.
So some good news. But going to planning and going to probate, again, if you can avoid going to probate, why not? The
Sure.
cost of the cost of a estate plan sometimes, in many cases, is much cheaper than the cost of probate. So doing an estate plan now, you're basically prepaying for your children's headache, because
Sure.
either you pay for the headache now and move on, and your children will not have a headache, or your children will have a headache and they'll pay more later. Or you're going to listen to me and you're going to bounce your last check and there is no issue,
Perfect.
right? But most people don't listen to me. Most people do accumulate. Most people do care about their children in some way or form, or not even children, somebody, loved ones, okay? And one of the things we have is, of course, most of the money in America, unfortunately, is the value of most of the money in America in residential real estate for most average people, right?
Sure.
It's the it's the assets itself, right? And then of course the secondary is life insurance policies and all that stuff. So one of the easiest ways to plan, one of the easiest ways to think about it is, of course, taking care of your checking account. One of the easiest and best ways is, of course, transfer and death designation,
Yes,
which
sir.
I'm sure you've done hundreds and hundreds of times. Could you talk about it? What have you done in the past? What is your experience about them?
Well, I have unfortunately seen many, many, many times, too many to count, children coming in after a parent has passed away and they don't have any access to the account. They weren't joint owners on any of the accounts where they had a little bit of reserve fund. They weren't beneficiaries or transfer on death of any of the accounts. I've also seen them come in, those same kids or other people that were to manage the affairs, with a POA, power of attorney. Guess what? The power of
Absolutely.
attorney ends at death. I'll look at it for like a minute and read it, conversate with them, give them the dignity before I have to tell them this is not valid because the attorney in fact, which you are, has no value after the
Absolutely.
principal is dead, and so it can be heartbreaking. So the transfer on death, or the joint tenant with rights to survivorship, those types of things have to be thought out while you're setting up the accounts, or even if you don't do it while you're setting it up, come back to the bank with the people that need to be on the account, or the people who need to be the ones that are the transfer on death to, or beneficiaries, and get that stuff set up.
Well, let's give a simple example. Let's say an individual A has a checking account in a bank, in your bank, let's say.
Sure.
Okay. Individual A passes away. The individual's A bank account, checking account, was only in his name, nothing else. A child comes in 2 days later, obviously distressed. She needs money to bury her father. Can you help?
I cannot.
Okay. What if she comes in about a week after and she has a death certificate? She shows you a death certificate, shows that she's the only daughter. Can you help?
I cannot.
But what if that individual had a transfer and death recorded in the account and the daughter comes in with a death certificate? Can you help?
Absolutely.
How fast?
Literally that same day, that
Same day.
in 10 minutes, I can make sure it's a valid death certificate and remove the deceased from the account and transfer the funds by cashier check to that individual.
Beautiful.
Very simple.
So the daughter would have enough money to bury the father in time.
Absolutely. The other thing is this. The TOD, the transfer on death designation, or joint designation, to my understanding, supersedes any will that was written about that account 10 years ago. Things change.
You are absolutely right. They're standalone designations. They're
And I'm
basically,
not an attorney,
but
but
I am.
you are. Now, here's the other thing. So and so, this might be the fishing account. And Jack has 20,000 in there because he likes to hunt and fish. It's all Jack's money, but he's got a buddy who's kind of a hangers-on, and he put Joe on the account so Joe could go buy some shotgun shells and things like. He kept Joe on the account. Guess what? He passes away. That $20,000 that was Jack's money is now Joe's because the dude wasn't thinking.
Absolutely,
And
because
it's not his spouse's, it's not his kids. That dude either takes the money as his own or does the right thing and gives it to who he knows really owns the money. But because he was joint on the account, he doesn't have to do that. He
no,
can take the money and run.
and that's why estate planning exists. Come and talk to us, ask questions, give us what if scenarios. Basically, do exactly what you and I are doing right now, because this is called planning. Talk,
Absolutely.
exchanging ideas. If you don't do it, your money is going to be somebody else's soon enough.
You're
Okay?
right.
So, transfer and death, beautiful instrument. Again, it's not a cure for all. This is not a panacea for all of your deals, but it's just an example of how easy it can be done for those that you leave behind to take care of your well, last wishes, let's say,
Sure.
or um, transfer on death deeds is a perfect liquidity instrument. Basically, if an individual passes away, you can have a standalone account just for that matter, where a transfer on death designates your executor literally to have cash available now until some other stuff happens, right?
You
So
know,
it's
yeah, you mentioned previously, a lot of times the house and the life insurance policy, are often the largest assets, whether it's a cash life insurance or just a whole, or a term, with really no cash value. You can't get to that money quick. It takes a while, you
absolutely.
know, and so those are really kind of somewhat illiquid, especially the house. With the TOD accounts at a bank, those are literally liquid. I mean, once we remove the deceased or designate the beneficiary, or we can literally get you money right there. And so, that's where just the foresight and the planning. I sit down with clients that just come in. I look over their accounts a lot of times, and I notice they've got significant assets. I don't see a power of attorney underneath the account.
Right.
A lot of times I don't see beneficiaries, and in many cases there's not even a joint owner. And so I'll ask these questions not as an attorney, but I'll just throw some seed out there and say, hey, do you want us to think about putting a beneficiary? What about a joint owner? Just because I've seen these situations, and guess where the pressure comes when these times of crisis? They sit in my office and they cry, or they get mad, or they don't understand, or they're emoting about, I can't believe he didn't have this taken care of.
Oh, yes.
And it's an awful situation.
And this is why we're doing this. Talk to somebody, give me a call, give Rob a call. If you need actual advice, give my office a call. But we're available. This is easy portion. It's
Sure.
takes few hours of somebody's life, and that's done deal. It's over. We
Yeah.
do it, we sit down, we come up with a plan, and we move on. So I want to talk about one more thing. So transfer and death.
Yeah.
Texas, about 4 or 5 years ago, was dragged into the 21st century. And we actually adopted a very good, I think, in my humble opinion, legislature. We actually created transfer on death for real estate.
Great.
It works pretty much the same way as transfer on death for banking. But please don't try to do it yourselves. Please talk to a lawyer because
Yeah.
but it's a beautiful, beautiful thing. So obviously, there's a number of caveats. It's not for everybody, but at this point, we can actually have a full estate planning done outside of the will and with almost 100% certainty without the interference of the courts, if it's done properly, of course. So 80% of the families you and I know have a basic setup. They have a house, they have a checking account, a savings account, maybe, right? And God willing, a 401k on IRA account, right? That's basically the basic setup
Sure.
of 80% of the individuals you and I know. And maybe
Absolutely.
some kind of a life insurance policy, maybe not.
Yeah.
So when people come to me and we do about estate planning, we do numerous things. So I go through the list of assets of what they have, and we talk about where would you like this particular asset to go. So with checking accounts, like we talked, we kind of have an idea what to do with them, right? It's
Yeah.
either transfer on death deed or some other designation, right? With the house, again, what to do with it? Would you like it to go to your spouse? Would you like it to go to your children? If you don't have any of those, would you like to go to a church
Yeah.
or a government beneficiary or any other things that you want? But speaking about a church, um, transfer and death deeds can be used to transfer to uh, churches, right? But there's a number of much better instruments to do it. But in theory, it can be done.
Yeah.
So if individual wants to take care of the church after they pass away, there is a cheaper way of doing it, such as transfer and death deeds. Or of course, there is a trust and there is grantor trust, and it's much more complicated. But since we're talking about it, it's a good idea to mention.
Sure. And I've my parents, if I can interject,
Absolutely.
and thank you for to the listening and watching audience for allowing us to be somewhat fluid. And this, we're just having a conversation. None of this has been scripted, other than my caveat in the beginning about I'm not giving legal or financial advice. But my parents, yeah, my parents work at an orphanage in Mississippi called the Tupelo Children's Mansion, and they are a 501c3 nonprofit. They take care of hundreds of kids, and it's a beautiful organization. I go there every year, sometimes 2 or 3 times a year. I volunteer, I speak, and they have had people that have left their entire estate to that nonprofit to keep it going. And sometimes it comes just when the need is the greatest. They've got an influx of kids. Maybe funding is down as it was in 2009. It probably is not going to be a great year for nonprofits the next couple of years because of what's happening. But someone thought ahead and said, hey, I want to do something good with some of my money when I leave. And so, you have that control while you're alive to make those decisions, because when you go and you pass away, probably someone's not going to be as generous as what you would have been with your money.
Oh, absolutely. And besides that, um, there are a number of tax benefits. Again, if properly planned,
Sure.
you actually give money while you're still alive and then finalize the gifts at the time of your passing. And again, it's way more complicated than I anticipated for this
Sure.
introductory, but something to think about it. And
Sure. Plant the seed.
obviously, I think help.
Now, can I also ask this question while we're in free flow mode? Um, is there a way to provision, for instance, and I know the law comes into place here, but I'm throwing this out. Let's say a man marries a second time, and they're living in the house, but he doesn't want her to inherit his house. It's his second wife. He wants his house to go to his children upon his passing. How does that interplay? Can you plan for, or are there laws in place? What happens to the spouse currently living in that house when he dies, even though she may not be the intended inheritor of it? What happens?
Absolutely. So
Because
here's
people need to think about this, don't they? They need to
uh,
know.
people don't, but I do 24/7.
Sure.
Okay, so if individual, let's say a husband, this is his house, he brought in a second wife, she moved in into his house, and he's very clear about his wishes. He wants the house to go to his biological children, and he made some other provisions for the wife. Maybe he didn't. It's again, it's totally individual, right? But he already made up his mind. So there's a number of things we can do. Number one is, of course, the Revocable Living Trust. Number two, transfer and death deeds. Number three, we have what's called life warrant enhanced life estate deeds, and we use them for Medicaid planning and to transfer to kids. But your second half of the question, what happens to the wife? As a matter of public policy and Texas Constitution, at the time of his passing, she has an unrestricted um, usage of the property until she passes.
Okay, so she's not just kicked out on the street here.
Yeah.
It's not an either or proposition we're looking at, because I think a lot of people would think it was either she gets the house or my kids. If they get it, she can't stay there, and it's
If
not.
properly planned, we can easily limit the amount of benefits the second or third wife can get, or a husband.
Sure, sure, absolutely.
Um, if it's properly managed, absolutely. But this life estate, which is not a life estate, it's actually literally a right to reside, is a matter of public policy and constitution in the state of Texas. So let's say somebody's father passed away, you are the inheritor. You have the documents, the trust specifically says the house is yours. However, his second wife can stay there until she chooses not to stay there or she passes. She cannot
Sure.
sell the house, she cannot mortgage the house, but she can live in the house.
So
Obviously,
you got,
obviously she has to pay the mortgage and all that stuff, if there is one.
and these are things that I've had to deal with as a banker, not on the legal side, but just of these events happening to people that I'm very involved with in their financial life. And you, as an attorney, no doubt, on a completely different level, both on the front end and back end of these situations, have experience helping people plan for those contingencies and answer their questions.
Oh, absolutely. As a matter of life at this time and age, right? Blended family is the new norm at this point.
Unfortunately, but it is.
Absolutely, but
Divorce rate.
right, it is what it is.
Yeah.
The third wife, fourth wife, fifth husband, unfortunately, is
Yeah.
more common than I thought.
You guys have heard that, I'm sure, that life insurance commercial about Big Lou's just like you, except he's only on number two. He talks about paying for his previous mistakes, regarding marriage and life insurance. And it's kind of a humorous commercial, but it's true. You look at the divorce rate, you look at the remarriage statistics, and if you don't plan for those possibilities in your big picture, it's going to kick you down the road.
It's a mess because what most people don't realize is that current wives have automatic rights into their 401ks, IRA accounts, and without beneficiaries and without their signatures, it's a mess.
Yeah,
People are getting money that were never supposed to get money. And
sure,
again, none of it is a problem if you don't care what happens to your money after you pass away. But if you do care, planning is a good idea.
sure,
One of the easiest and best instruments we use for blended families is Revocable Living Trust. It's something to think about it. It's something to maybe read upon. And if you have any more questions, give me a call. I'll be more than happy to talk about it. But basically, it's the ultimate instrument for a family estate planning that we have so far. It's a good blend of complicated and non-complicated documents.
sure,
Basically, set you up for good. It takes care of everything we talked about it in a sense where the transfer and death deeds for the house and for uh, the bank accounts basically are incorporated into a trust language in a
yeah,
sense. But again, it's not something to talk about now. It's more
right,
of planting seeds. But the way I talk to people about trust and wills is a very interesting question. Will is a gateway to a probate court, right? A will is a wish list. You write a wish list, and this is what's going to happen after I pass away. But
sure,
the judge has to basically approve it.
yeah,
It's a legal proceeding. You have to have a lawyer, you have to have an executor, you have to have a judge, you have to file, you have to wait. It has to be public, by the way.
Can you say that one more time? Because I have people coming into my office with a death certificate and a will, and they want me to do something with that will. I'm like, I can't execute a will. I can't make those decisions. I don't have the legal expertise to make a judgment on this.
Absolutely. So let me be clear. A will is a gateway to a probate court. You still have to have a judgment from a judge on exactly what this will means or whether it's actually a valid will. Does it work? So a will is basically a wish list.
Yeah.
And it's
Now, can I give you the opposite of that, the other side of that?
absolutely give me
I've
that.
also had people come in and lay trust documents. Now, we didn't have the trust maybe at our bank. Maybe we did. But they have a trust document that they drop in that allows us to set up a trust because maybe they bank with us personally, but they were a successor TTE or successor trustee on some trust documents. They bring those documents in. We send them to legal. They review it. We set up the trust account. They take the trust money from the bank that their parent or somebody else had, cut a check from there. They come bring it over to our bank as a trust, and the trust never dies unless it's stated in the trust. The terms of what's going to happen here. And so,
I simply love them.
yeah. So, when they do that, or they were the co-trustee or the beneficiary of the trust, then I have the ability to immediately begin executing the wishes of the decedent who had the foresight to plan and to place those assets and directives into a trust, whether it's revocable, irrevocable. We can execute that document once it's approved. Just makes it so much simpler, cleaner.
Besides simple and cleaner, there's also one other thing that you also think about it. It's private. All probate documents, all probate filings are public.
Public. Yeah. Yep.
Okay, so people will know what you got, where you got it, where is it. So in this day and age where information is the king, do you want your family affairs to be public? Because guess what? The second you file for probate, a whole bunch of scavengers are going to be knocking on your door trying to buy your parents' property on 50 cents on a dollar.
Absolutely.
Because they know for a fact that you cannot make good decisions at this time. You just lost a loved one. You are distraught. You are not in a good place. And you're going to be getting all these letters and everybody on the door knocking saying, well, I know you're about to inherit this piece of land in Albuquerque. Would you want to sell it to us? We'll buy right now for cash. Here's the money.
Hey, I got the check.
I got the check. So as a matter of, again, basic principles, if you can avoid scrutiny by the public, if you can make this into a family affair, why not? So my preference again goes to the trusts, right? They are simply a private document for a family to take care, widely recognized on every level of banking and government entities. And at this point, it is still a preferred method of estate planning for most of my clients. So also, I want to talk about one more thing before I forget. Since we're talking about planning, and you were so kind enough is to give us a little bit history on the Bible. There's another document that I like to talk about, and you're probably gonna have something to say about it. It's the disposition of the remains document. Okay.
What
I
happens with the body?
It happens. I don't have to tell you how many family fights can be avoided if you can designate a single individual to take care of the funeral arrangements.
Sure.
And I am sure you know from your personal life and as a banker, I'm sure you've heard the stories and you've been part of the stories where family members are basically yelling and screaming and suing each other on
Sure.
who is to organize mama's funeral, let's say. This is again, this is to keep peace in the family.
I'll give an example. In the past, and even in some Christian sects and denominations, um, really cremation has been viewed very negatively, almost pagan, because of some of the other cultures that may burn the bodies in religious rites and things on the river and things like that that Christians don't necessarily want to be associated with. But cremation has gained a little bit more favor, I think, in broad Christian circles as a viable death option. However, some people don't jive with it, man. So you got mom dies, and maybe she's the last parent to pass away, and you've got one kid that wants to cremate because mom told her that a day before she died, and the other says, no, cremation is cruel, I can't bear it, I can't imagine mom being burned and have her ashes and things. And it becomes at the time where they need to be coming together because they just lost the matriarch of the family. They're arguing over how she should be, what happens to her body, and that should be done way ahead of time.
Absolutely. And if it's something that important in the family, some cultures or families simply don't care. It's part of their
Right.
upbringing. It doesn't matter, right? Whatever happens, it's okay. The
Yeah,
individual
sure.
is done.
Yeah,
For others, it's important, right? It's the passage to the afterlife. It's the passage, it's the way it was done for thousands of years.
sure.
Again,
Yeah.
for the family's sake, it's a very important document. Just have it.
Yeah, if you want to be buried with the cremation remains of your favorite pet, you can do that. If you want your baseball cards, Dad, to be buried with you, your Mickey Mantle card. I mean, you could do that if you wanted to. I'd recommend selling it, but that's up to you, right?
Yes.
You got to write it out.
And again, I don't want to be repetitive, but planning, planning, planning. But what's really nice about it, I mean, as come from a different culture, from a different country, here in US and Texas, it's all available, right?
Yeah.
where I came from, none of this was even phantomed. This is not something people thought about it. The legislature never created laws about it. It just never happened. You had to go through a procedure. It was a one procedure. You have to go through a court, and it was a burdensome. It wasn't planned out. It wasn't thought of. Here, we have all of this. It's beautiful. It's awesome. It works in most cases, right?
Yeah.
We have a whole body of laws and lawyers that can help you with this. So the question is, why not? Right? So going back to, if this is something you want to think about it, please do it. If you don't listen to us. This would be a waste of time, because if you're not a planner, this is of no importance to you at all.
Yeah.
But if you are a planner, please take advantage. Texas has beautiful laws that you can implement.
You know,
Yeah.
it's kind of interesting. The solution, whether they plan or don't plan, is pretty much the same. They're going to need a banker. They're going to need a lawyer. They're going to need to contact a life insurance agent. They're going to need to contact the investment professional handling the estate. The only difference is the timing, the emotional toll, and the ultimate cost. Think about this. If you wait and do it when you're gut wrenched because somebody died and you're pressed for time and you're scrambling to get a ruling or a judgment or find a lawyer, it costs more time, it costs more money, and it costs more emotionally than doing it in advance.
You see, what most
In
people
my
don't
experience.
what most people don't realize is that the government already written a trust for them and a will for them. It's called the estates code. And if they don't plan it themselves, it's all written there. The code specifically enumerates who gets what, how, and which way.
Sure.
That's it. They think they don't have it. They do. Everybody who dies in Texas has a will written for them. They just don't know about it. It's called the estates code. It's specific. It specifies who gets, how, when, at what point, who makes the decisions, and how much it costs. So if you don't plan, somebody else planned it for you. Don't worry. The
Yeah.
government did it.
The government, right?
You can trust the government. The government planned it out for you.
Well, that's reassuring.
Absolutely. So, as a tie-in, it looks like we're getting closer to the end because we don't want to keep this for longer than an hour. As a tie-in to all of it, I'd like to say this. So, as a basics of estate planning, we usually use two ways of doing it. One of the ways is the contract law, which is basically the trust, transfer and death deeds, designations, and all that stuff, right? Or we use the probate, which is basically the will, where you write everything out and you go to a court and the judge will decide what's happening, right? So as a matter of estate planning, we as estate planners like to use the contracts to contract everything out. What happens to your LLC, to your business? What happens to your house? What happens to your bank account? What happens to your life? What happens to your health? And they are documents. They're a set of laws that we can use to basically engulf you in all legal protections. And God willing, you're never going to use it because you won't. But unfortunately, if you do pass away, if somebody in your family passes away, it's all set up. Also want to just throw this out. As a planner for a numerous churches and other religious organizations, in my personal experience, what I've seen, the trust are the easiest ways to pass money into your church. It's cheaper. It is almost always works like a charm. And it's a beautiful benefit to endow something that you think is important to you. So just think about it. And I'm sure Rob, as a pastor now, can tell you what he thinks about these things.
You know, I have actually made provision in my financial documents to do the same thing, to leave a portion to the church that I'm a part of and the organization that I'm a part of. And I do that because, you know, if I were to live indefinitely, I would continue to support those things financially. And so as part of my life insurance planning and retirement planning with my assets, you know, I plan to do that as well because I care about the organization I'm a part of and I care about my church. And so, just like with the example I gave with the Children's Mansion and other things, if you have a nonprofit that you care about, that you're nurturing while you're alive, um, you can designate that in your trust. Just like that cat or dog, you make sure they're taken care of. So you get the power to do that. You can bless whoever you want to with some planning.
Absolutely. And on this wonderful note, I think we're going to end this beautiful conversation of ours. Rob,
Yes,
as
sir.
always, it was the pleasure talking to you. Um, and
Thank
everybody,
you.
uh, if you need to get a hold of us, our information is going to be available to you. It's with my last
Post a comment too, right?
name.
Comment. Put us your
Comments.
email address if you want to do that. We'll email you, say hello.
Leave us a message, call me, text me, send me a pigeon. Anything works. If you have need of help, I will be available. And as a little bit reminder, Rob will contact his parishioners because we have a very interesting proposition for them. And
Yes,
I'm
sir.
sure Rob will do it privately. This is basically a benefit to his churchgoers, and I am going to be extremely happy to help him with that. With that
Well,
being said, everybody, please stay safe, healthy, and good luck.
thank you. God bless. Good to see you, Leo.
Take care.
Talk to you soon.
Bye bye.
Bye bye.